Consideration of motions filed in the matter of Daniel Fontenot, Department of Public Safety and Corrections, Office of State Police, docket number 22-260-S. Good morning, sir. Morning. Again.
Good morning, Michelle Gerard, on behalf of Office of State Police. We do oppose this motion.
All right. I kind of figured that when you jumped up to the seat there.
And Michael Andrew for Mr. Fontenot, sir.
Good morning, sir.
Good morning.
It's your motion.
Sir, we filed a motion for summary disposition. We feel that, well, the facts show that he's clearly entitled to the relief that he sought. What we have is a very good trooper, 20 years, master trooper. He trains he's a DRE instructor, LIDAR instructor, SFST instructor. He served the state police honorably. He's got no blemishes on his record thus far. He is a by-the-book type of officer. The facts are not in dispute. There was another trooper whose performance was not as stellar as his, not even almost, to the point that it was affecting troop morale. It was causing issues. He went to his superiors and he asked them to intervene, to correct the situation. And they effectively said, handle it yourselves. So he did. And under the commission job specifications that are online, for Master Trooper, he has the ability to exercise functional supervision over subordinate officers. So while in uniform, in his patrol car, on duty, and while she was in uniform, in her patrol unit, and on duty, he counseled her in order to protect himself, protect the state police, and protect the department from potential retaliation. Her maybe saying that, you know, the conversation went away that it didn't go. He activated his body-worn camera, again, while on duty and in the discharge of his official duties, to document the conversation, just in case she ever filed something frivolous saying that the conversation did not go the way that it did. He did not weaponize this against her. He didn't tell anybody about it. He saved it in the system. He didn't spread it to other troopers. He didn't go tell his buddies that, you know, they had this counseling session. It was purely to protect himself and promote the future efficiency of the department, because, as we all know, litigation is inefficient. And documenting the situation would show exactly what occurred. And there's no question as to what occurred. It's on video. There's never been an allegation that he did anything inappropriate. The LSP is simply mad that he recorded the conversation. He presented himself to IA, gave a full and truthful account of what had occurred. And frankly, we were floored when we learned of the decision to discipline him for violation of the body-worn camera policy, which states that troopers are not supposed to record one another except in the discharge of their official duties. And there's also a little open door provision in the body-worn camera policy that says that we cannot contemplate every situation where a trooper may need to use his body camera. We just can't. And therefore, whenever a trooper thinks it is valuable and necessary to document an incident, he may use his body camera. This is a by-the-book kind of trooper. He knows policy. He did what he thought was in accordance with policy. Several other troopers, including sergeants, retired sergeants, other master troopers, have given affidavits that he is not the type to violate policy. He's actually the exact opposite. He's the kind of cop that bad cops don't want to have around. There was absolutely no bad faith in what he did.
And isn't that a question of fact?
Of bad faith?
Yeah, whether he did or did not act in bad faith, isn't that a question of fact? I'm not prejudging it one way or the other, but isn't that a question of fact?
Well, it can be, sir, but if it is a material fact,
can be,
the question is whether
but if it can be, can I finish my question?
Sure, yes, sir, yes, sir.
All right, if it can be, how can we decide this on a summary disposition?
Because I don't think it's a material fact. Even whether it's a fact or not, the question is, did the actions violate policy? And under the black letter wording of policy, we don't believe he did. And furthermore, another trooper...
Don't we have to determine the facts in order to decide whether it violated the policy?
Well, the policy doesn't have a provision that says if it's done in good faith, it's okay, if it's done in bad faith, it's not. It just says that a trooper can use his body-worn camera in the discharge of his official duties. I don't think it's disputed that he was on
And
duty.
don't we have to determine whether or not this was in the discharge of his duties? Factually?
I don't think there's been anything presented by the department in their opposition that opposes whether or not he was on duty, whether or not he was discussing his official duties with another trooper who was in her official duties and also on duty. And when a mover presents something and it's not rebutted, then it's accepted.
But in a discretionary act, you would agree that was a discretionary act on his part, right?
To record?
To record, yes.
Sure.
In a discretionary act, don't we have to consider the motivation of the actor in determining whether or not it was done in furtherance of his capacity in his official duties?
And again, the circumstances indicate nothing to the contrary.
We have to make that factual determination, though, right?
Not really, no, sir, because with a summary judgment, if facts are not disputed, and there have been no...
Well, I understand summary judgment thoroughly. I've been doing it for the last 41 years.
Sure.
Okay, but my question was, and that would be a material fact, would it not?
Which facts, sir?
The fact of the motivation with which he acted at the time to determine whether or not it was done in furtherance of his duties.
Sir, I think the step one is determining whether or not his actions violated policy, and I do understand what you're saying, that, but if he was in the discharge of his official duties and that has not been rebutted, then I don't even know that we need to get to motivations and things. I briefed it extensively.
Wait, there's a difference. We can't conflate everything together. I don't think, and I don't want to speak for the department, but even if I accept that what he was doing in this counseling session, is that what you want to call it, a counseling session? Sure. I don't think anyone, at least I'll accept for the purposes of your argument, that the counseling session was in the furtherance of his duties. The question, though, is whether or not the use of the body camera was in the furtherance of his official duties, right?
Sure.
Okay. So is there not a question of fact that has to be determined as to whether or not his motivation was such to take that action outside of his official duties?
Well, and does a question of fact exist? It does. We briefed it, but I don't believe that it's a material fact, because I believe that whether he was on duty discussing issues concerning his official duties with another trooper who was also on duty, applying that alone to the black letter rules, the policy, he's within policy. The motivations is a secondary question that I don't think is material to the determination.
So you would argue that as long as it's within that first part of the rule, we don't worry about motivation. That's your legal argument.
Yes, sir. Yeah.
Okay.
Yeah.
I now understand your legal argument. I'm not saying I agree or disagree with it, but I now understand where you're going. Okay.
Yeah.
But if I were to disagree with it, if we had to get to the second part of it, would you agree with me that if we have to get to the second part, that becomes a factual question?
It would, and again, I would posit to you, sir, that we have presented affidavits, which are perfectly allowable under the rules, and other information that set forth and that support the contention that it was all good faith, and there's been nothing presented to rebut that at all, except statements that the appointing authority simply disagrees. And he wasn't there, he's not a factual witness. There's absolutely no circumstances that rebut that his motivations were in good faith.
So you would say it's not in dispute?
It's not in dispute.
Material, but not in dispute?
Not in dispute.
Okay.
So as far as the mechanical recording policy is concerned, I believe that is a legal determination that does not require any issues of fact. I briefed that extensively. The policies do not cross-reference one another. The mechanical policy was in effect long before the body-worn camera policy was in effect. The mechanical policy is worded in a way that it does not reference the use of body cameras. They're distinct. You've got digital versus mechanical. He interpreted that and did not feel he was in violation of it. We have an affidavit from Dr. Steve Thompson. He was a 10-year trooper. He has military experience. He was a military police sergeant. He's got his PhD in public safety, teaches at McNeese, and trains at the Southwest Louisiana Training Academy. He was Trooper Fontenot's FTO, and he presented an affidavit in conjunction with this saying, I would have trained him to record that conversation. It was official duties, and it was well known at the time that we were training Trooper Fontenot that the mechanical recording policy didn't apply to body-worn cameras, and I would have trained him that it didn't apply to body-worn cameras. So now we have another fact that is not in dispute, that that he just acted in accordance with his training. Moving on to the conduct unbecoming argument, I really don't know where that came from. Dr. Thompson also teaches policy interpretation and application, particularly with regard to whether they have ethical motivations. And he thinks, well, he has put in his affidavit that he just sees no basis for the conduct unbecoming. I'm really not sure what it's based on, except something to do with the conversation that he had with his superiors and how he recounted it to IA, and how that was just an honest account of what occurred. He went to his superiors, he asked them for support, they refused to step in. The burden fell on him. He did his duty rather than neglect his duty by addressing the situation, and somehow that constitutes conduct unbecoming. The facts just don't support that. And at the end of the day, even if there were some sort of violation with regard to any of this, the case law is clear that in order for there to be cause to discipline, there must be a real and substantial impairment of the efficient operations of the agency. And I don't think there has not been any real and substantial impairment to the operations. Sergeant Chris Hill presented an affidavit saying he has never heard of anyone being disciplined for actually using their body camera. I can tell you as a defense attorney, if I had an officer on the stand and asked him if he had a blemish on his record, and he said, yeah, and I said, what for? For using my body camera, it would be surprising at the least. If anything, what Trooper Fontenot did was in the furtherance of the efficient operation of the agency by remedying the poor work performance of another trooper and by protecting himself and the department from potential suits by recording it and saving it to document exactly what occurred, which is exactly what body-worn cameras are for. As a criminal defense attorney, I can tell you more times than not, 9.5 times out of 10, that camera footage proves my client did something wrong. It covers the police. It shows that there was no excessive force used, even though the client says there was. It is a method to accurately and objectively document a situation to protect the officer and the agency from improper litigation, which necessarily promotes the efficiency of the agency and its operations. And for those reasons, we ask that our motion for summary disposition be granted, and I'm happy to answer any questions that you have of me.
Any other questions? Mr. Romer.
Morning. I feel like I'm arguing the facts here that should be at a hearing where we have witnesses and testimony for the commission to make a decision. But this is a motion for summary disposition. And although the appellant did file a lot of affidavits, although I would argue that they're irrelevant to the matter at hand, what you can also consider is the letter of discipline. You have the appointing authority's statement of the facts and his opinion and interpretation of state police policy, which is very relevant to this matter. You have not heard from the appointing authority other than in the letter. So when we get to the facts are that you had a trooper who took it upon himself to do the duties of a supervisor. Whether he thought the supervisors were acting appropriately or not is not for him to decide. Engages in a conversation with another trooper and records it on his body camera that is in violation of policy.
Was there a direction to him to handle the matter?
He said he was ordered to. No one has said he was ordered to do it. He took it upon himself, according to the statements obtained during the investigation. So a decision of, I'm gonna do this because I don't like what another trooper's doing, versus a supervisor ordering him to do it, are two clearly different things. The policy
So
says.
where are the facts that dispute that claim? You're saying that that there's a dispute over whether he was ordered to do it or not. Did you submit anything that disputed that fact?
I'm not aware of anything, any affidavit from any supervisor in the motion for summary disposition that says he was ordered to do it. The letter says that he had a conversation with a supervisor who said, handle it amongst yourselves. That doesn't mean go speak to her and record it. He could have had the conversation in the presence of another supervisor. If he was concerned that something might have been said during the conversation, he could have either avoided the conversation or had someone else present during the conversation. But instead, he violated the policy when he used his body camera. So if he wants to take the position that it wasn't a mechanical recording, which I'm just not following, if you don't know what a body camera is, it's a device they wear, and you have to.
We know what a body camera is.
You have to begin the recording somehow, and you either push a button or something triggers it. And I believe in this case, he didn't activate his light, so he would have triggered it by pushing a button. That's mechanical in my interpretation of what mechanical is. Whether the recording was digital or a little wheel turns to put it on a tape, he mechanically recorded that. He didn't sit and transcribe it by hand. So the appointing authority has already reviewed the facts as stated in the letter, and I'm going to point out that appellant doesn't dispute the facts, that the incident happened, that he activated his body camera and recorded the conversation. Those are material facts that aren't in dispute. Whether or not the policy was violated is in dispute, and how can you make a decision without hearing the testimony and evidence? The affidavits that are attached, I would argue, are relevant. If you've read them, and I hope you have the 76 pages that was presented in the motion and the affidavits, we have statements regarding another trooper's ability to function as a DRE, which is completely irrelevant. We have an affidavit from someone in the military who's never served in state police, which is irrelevant.
Let's put aside the affidavits right now. I want to talk about the legal arguments that were made. What about his legal argument that the recording was done in furtherance of his duties, and therefore it's not a violation?
I'm not aware of any duty that he had to go meet with the trooper and counsel her. He's not her supervisor. So the agency's going to take the position it wasn't a duty he had.
All right, well, to be fair.
That whole issue's in dispute is the point here. I mean, for the commission to sit here and make a decision without hearing any testimony on the situation, you have the appointing authority's letter. If we need to start drafting letters in affidavit format, for the colonel in a sworn affidavit to state, I find the trooper violated policy, we can do that. But, you know, these are material facts that the trier of fact has to hear all the testimony and evidence to make these decisions. When you're talking about an opinion
But
on
whether
policy,
he violated policy or not is really a legal question. So we have to rely on the facts right now in the letter, because we can look at that, and I'm not disputing that. But my question to you was the legal question of whether or not you would agree with his argument from a legal standpoint that if the body camera was turned on in fulfillment and the course of his duties, that does not violate the policy.
well, I mean, I'm going to say that's the appointing authority's decision, and he must have made that determination in the letter. If we were going to question was it his duty or not, I think we have to have testimony on that. So what you want to do, because you know you're trying to remedy something that you believe is a problem versus you're a supervisor in someone's performing their duties. I mean, I think that's a question for the appointing authority.
All right, thank you. You can go ahead. I just wanted to get that question answered.
I was speaking about the affidavits. I think we're trying to cloud all the issues here with the 76 pages and all the affidavits submitted. I went through it, and there's the majority of it, I believe, is irrelevant and not necessary for the commission to make a decision as to whether or not the policy was violated. He brought up Mr. Thompson. He retired from state police in 2013 according to his affidavit. I don't believe state police had body cameras in 2013, so I don't know how he would have or could have trained him on when it was appropriate to use the body camera or not. Another affidavit talks about his fellow trooper's DRE status, which is irrelevant to the proceeding, and I'm really confused as to why there's an official state police report of an evaluation in there with someone's name on it, what that has to do with the facts here about him recording his conversation with his fellow trooper. So we also ask that not only the summary disposition be denied, but all these materials be stricken from the record as they're irrelevant to the facts at hand here. And also, interestingly, if you read through, and I don't know if we're going to have another motion argued after this, but if you read through it, this has become an attack on the trooper that was the other party to the conversation who was recorded. Some allegations in there that there was a need to record the conversation, and if those are true, if he was so worried, he could have just avoided the conversation, period. But Trooper Fontenot put himself in this position. So for these reasons, the facts are what occurred. The appointing authority has outlined the conduct that occurred. He also made his determination of the policies that were violated. The facts outlining the conduct have never been challenged. In fact, they've been admitted by the appellant. So where we are, the material, the questions that remain are whether or not policy was violated. And that can't be decided based upon the information presented here. You have the letter, the appointing authority's opinion and decision in there, and without any testimony as to whether or not it was violated and how the fact pattern violates the policy, we think summary disposition is inappropriate at this time, and it should be referred to the hearing on the merits.
Brief response.
Yes, sir. Maybe I got ahead of myself with my legal argument earlier. It all starts with what is summary judgment. When both parties have an opportunity to conduct adequate discovery and certain facts are no longer in dispute, then there's no issue of genuine material fact. The court can make a ruling, or in this case the commission, on how those facts apply to the law. One party cannot simply not participate in the discovery process and then say this is a matter for trial because we got facts we got to decide. We're conflating the appointing authority's capacity as arbiter and fact witness. He has already determined that this is against policy in his opinion, and that's fine. But now it's the commission's turn to decide if what happened is against policy. They could have presented affidavits. They could have presented witness testimony. We have the disciplinary letter, and I understand the commission's going to accept all of that as fact. That is their facts. I have submitted facts, most of which are not disputed and that are material. And when you look at their undisputed facts and our undisputed facts on the issues that matter, the genuine issues that are decided now, no one's disputed them, we're still entitled to relief as a matter of law. Summary disposition is absolutely appropriate. The department could have presented any witnesses, any affidavits, any other...
Doesn't present any witnesses.
Yeah.
Well, in any event, other facts that they wanted to dispute ours, and that did not occur. But in any event, I wanted to bring that up. And as far as the relevancy of the affidavits, they're relevant in each item we have presented is relevant on a certain point, and many of them are relevant on other points. To establish, talking about the complaints that this trooper filed after the fact, that just shows that Trooper Fontenot's gut feeling was correct in the beginning, that there could be retaliation if he didn't document that conversation. The affidavits speak to what a good trooper he is and to his performance. The affidavits also speak to, whether or not some of these issues were occurring to a frequency and degree to which it would have been reasonable for him to feel like he needed to step in and correct it to promote the efficiency of the department. And to say that she's not a subordinate, the way I read the specifications on the commission website, which he actually cited in the IA report, is that a master trooper can exercise functional superiority over subordinates. He's been there 20 years. Sergeant Sal Messina said in his affidavit, that's what a master trooper's for, to handle problems before it gets to a sergeant, if it can be handled by a master trooper. He did absolutely nothing inappropriate, and he sought their intervention. He was denied their intervention and told, y'all can talk it out. It may not have been couched in the formal terms of, I'm ordering you to go talk it out, but at the very least it's an authorization, and it's how he interpreted it. Regardless of that, any day of the week, just as a member of the public, I would want a good cop to make sure that things were running as efficiently as possible rather than turning a blind eye to inefficiency. And that's what he did, and he's been punished for it. And we're asking the commission to do the right thing as the neutral arbiter, somebody that doesn't have a dog in this fight. Many of you are in law enforcement. You know how hard it is. When you're picking up slack because somebody else isn't, it's a hard job. Everybody's got to carry their weight. It was affecting morale, and he did what he thought he needed to do for the troop. If that is censurable, then that is regrettable. And if his interpretation of policy is incorrect, the policies that were given to him and he was just told to read them and learn them without any instruction on their meaning, then a letter of counseling is more than appropriate to redress the situation.
Any questions or comments?
One thing I would like to point out, Mr. Chairman,
Extremely brief.
there is no discovery in these proceedings. We have not had the opportunity to engage in discovery, take depositions.
We're familiar with the process.
Thank you.
All right, thank you. All right, any questions? All right, entertain a motion to go into executive session to discuss the allegations.
Second.
To discuss the allegations of misconduct. You gotta make the record. Any discussion at this point? Do we have any motions?
Make a motion, Mr. Chairman. This is in the matter of Daniel Fontenot, docket number 22-260-S. There was a motion made for summary disposition of the appeal by the trooper, Daniel Fontenot, and on that behalf, I would move that we dismiss the request for summary disposition. Second.
Then moved and seconded. Any discussion? Obviously, a vote on this issue is not a vote on the merits of the discipline. It's simply a vote on whether we as a commission feel that we are in a position to summarily decide those issues without the presentation of evidence. So, any other discussion? All in favor?
Aye.
Any opposed? The ayes have it.